webinar of the year. As you can imagine, we are working heavily on the planning of what we will organize during 2021, and you will receive in the upcoming weeks a lot more information on our other webinars and the virtual educational events that we will organize during the year. For your information, we are recording this session, so it becomes available for our BATM members through our website. And one other housekeeping note, that if you have any questions, feel free to submit them in the Q&A function of the Zoom application. We will be more than happy to handle them at the end of the presentation. Obviously, I want to thank CIBT for the partnership this morning in organizing jointly this session around the business after Brexit and the impact of the Brexit on business travel. So with no further ado, I'll give the word to Tony and Joyce. Thank you very much.
Thank you, Pascal. Good morning, everyone, and welcome to this webinar. And thank you, Pascal and Sophie, for the invite for Tony and myself to present you some slides around Brexit. My name is Joyce Nijdenberg, and I'm the Managing Director for CIBT Visas in the Benelux region, based in The Hague, but started in Belgium around 9 years ago. And with me today is my colleague Tony, and Tony is the Managing Director for Newland Chase in the UK. CIBT is split within two main brands: CIBT Visas, who is responsible for short outbound visas, and Newland Chase. And Newland Chase is dealing with all kind of immigration cases, but also a lot of expert colleagues on Brexit. And although I'm sure that a lot of you are not even thinking on, well, hope to think on traveling again short term, we know that COVID is still on top of minds, and with a lot of travel bans, it's just not easy to travel at the moment. Brexit is a very important topic that we really want to talk to you about today, and my colleague Tony will take over now to start the presentation and give you more information around Brexit and the changes in business travel. Thank you,
Great.
Tony.
Thank you, Joyce. Thank you, Pascal. Very nice to be with you this morning. I hope you're all well, all healthy, all staying safe. So just a brief run through of the agenda. The points I'm going to cover today: I'm going to have a look at the end of the transition period. I'm then going to move on to the UK employment routes from a visa perspective, and some of the things you need to be thinking about if you're looking to employ foreign workers in the UK now. Looking at your sponsor license process, and that kind of ties into the first point that I'd mentioned now. And then we're going to focus on business visitors and how things have changed post-Brexit, why it's important to look at business visitors in the post-Brexit world, because things have changed quite significantly. And hopefully we'll have some time at the end for Q&A. So as Pascal mentioned, if you'd like to post any questions that come to mind as we go through today's presentation, then do feel free to just fire those away, and I can answer those at the end. And if there's anything you'd like to take offline, then our details are set out at the end. So I'm going to be focusing today just on EU nationals coming to the UK. But frankly, it's actually all foreign nationals. And I think the first point really to mention, just to get this out of the way, is that from the 1st of January this year, EU nationals are now treated as foreign nationals as far as immigration into the UK is concerned. I'll start going through the bullet points. I think that's the best way to sort of frame today's presentation. So back at the start of last year, we signed the withdrawal agreement, which sort of set out the plan for citizens' rights post-Brexit. There was a period through until the end of the year where essentially free movement rights were maintained, which is to say that EU nationals who came to the UK before the end of last year were allowed to live and work as they always had done. And I'll come on to the next point about what you need to be thinking about for your EU nationals who were in the UK before then. But ultimately, free movement rights came to an end on the 31st of December. And I suppose really this sets the scene for the rest of the presentation. There was the free movement, which we all enjoyed, actually, Brits into the EU and vice versa for over 40 odd years. And now we're in this new post-Brexit world, which is very, very different. And I think that's the one thing to bear in mind as we start to go forward, as global mobility and travel starts to pick up again, that things are very, very different to what they were previously. So we're out of the transitional period now. We are in this post-Brexit world. But you may well have a group of EU nationals, if you look after teams of employees who are currently in the UK and were in the UK before the end of the year and wish to continue to live and work in the UK. The Home Office in the UK implemented a scheme called the Settlement Scheme, and that was essentially to allow all EU nationals who arrived in the UK before the end of last year to apply to allow them to continue living and working here. There is a deadline by which they need to apply, which is the 30th of June this year. So again, if you are responsible for managing a group of employees who are in the UK, then I would recommend you send out comms just to remind them that they do need to apply. It's important that that's sort of set out quite clearly. We have had, questions and spoken to people who actually don't think they need to do anything because they've been here for a long, long time, or they're married to a British citizen, or they have children who were born in the UK, and so on and so forth. But that actually is a compulsory scheme, so they must apply. If come the 30th of June, they're still in the UK and haven't applied by that deadline, then they will be here unlawfully, unfortunately. So, just something to make you aware of, and in turn for you to sort of think about comms to your teams. Which I suppose essentially brings us on to what the landscape looks like now. And as I mentioned at the start, EU nationals are now considered as third country nationals or foreign nationals in the same way that we would think of Americans and Indians and, so on and so forth. So the post-Brexit framework for immigration started on the 1st of January. All those who are arriving here now to work do need a work visa. And I'm just going to now go into a little more detail about the available options for those people who are coming to the UK who wish to work. Okay, so I've set out essentially 3 options here. There are, of course, other visas which entitle people to come to the UK. There's investor visas and, entrepreneurial schemes, obviously family routes if you're married to a British citizen. But what I'm going to go through now are really the main employment routes which will be available to your organisations in the UK. So some of you may be familiar with the old points-based system, Tier 2. We had the Tier 2 General and obviously the Tier 2 Intra-Company Transfer. But as a result of Brexit and our departure from the EU, the government decided to have really a reassessment of the scheme to look at whether it was fit for purpose in a post-Brexit world, given that EU nationals were no longer going to be able to benefit from free movement. So the ease of just being able to come here under free movement and start working obviously no longer exists. As a result, the government sort of did a wholesale re-evaluation of the old scheme. And the changes actually are quite favourable. And I'm just going to highlight some of those in contrast to the old scheme. So we'll start with the skilled worker. Some of you may be familiar with that, or with the old scheme, which was called Tier 2 General. And that's essentially the scheme in the UK, which is designed for permanent hires. So if you're looking to move somebody or hire somebody into the UK on a permanent basis, this would be the visa, the work permit route, which you would want to use. So in the past, there was a requirement for companies to advertise the role for 28 days to show that they couldn't find a suitable settled worker. That's been removed, so there'll be no advertising requirement, which is, very, very helpful. It's actually often quite frustrating that companies had that time delay, then all the admin around the advertising, the sifting through CVs and, the interview process. all in order to actually offer a job to a foreign worker. So that's no longer the case. Also, there are no longer annual limits, or at least they've been suspended. So again, under the old scheme, there was an annual limit, which is essentially the number of work permits that the government would issue to organisations. That's been suspended, again, in response to Brexit and the need for us to, be able to continue to hire from outside the very sort of, small domestic labour market, which is really now the only talent pool which we have available to us in the UK. We also reduced the minimum salary and also the minimum skill level. So before, the skill level was set quite high at graduate entry level. That's been reduced down now to the equivalent of A-level standards, which means a lot more roles will qualify. Again, going back to Brexit. There is an English language requirement, however. So just one thing to point out, that in order to qualify for a skilled worker, the individual has to meet an English language requirement. That can be done in one of three ways. Either that they have a degree taught in English, that they have a passport from a majority English speaking country, or they have an international English language qualification. It's worth pointing out that EU nationals do not automatically meet the English language requirements by virtue of holding an EU passport. That doesn't apply. So if you were looking to sponsor somebody under the skilled worker route from the EU, then if they didn't have a degree taught in English, they would need to apply for an English language test. Just do bear that in mind. And the final point, it does lead to permanent residency. So after 5 years, if you have an employee who's maintained their continuous residence in the UK, then they will be able to apply for indefinite leave to remain. Okay, so as you can see, it's a long-term route. Does lead to settlement, and the qualifying criteria has been reduced quite substantially in contrast to the old scheme, so it certainly is more attractive than it used to be. But there's also the intra-company transfer, and this is more designed for temporary assignments, secondments, maybe for short-term project work. In actual fact, the Home Office haven't changed the intra-company transfer route very much at all. There was never any advertising required. Okay, so nothing's changed there. The minimum salary previously was set at 41,500. That's the minimum that you would have to pay an intra-company transferee. Again, the skill level continues to be set at degree entry level. Okay, so just do bear that in mind. If you're looking to send somebody on a short-term assignment to the UK, do make sure they qualify on the skill threshold. And just to sort of give you an example, the skill threshold that I'm talking about is the role itself in the UK, not necessarily the individual skill set. So they don't have to have a degree themselves, but the role itself needs to be at the requisite skill level. Okay, so do bear that in mind. There's actually a list of roles that the Home Office publish that we look at to make sure that they meet the minimum skill criteria. So we would always look at the job description of the role on offer and then assess that against the published guidance. Again, the intra-company transfer is temporary in nature, doesn't lead to settlement, and it's capped at 5 years. There are some exceptions to that, but typically the individual can only stay for 5 years before they then have to leave. However, there's no English language requirement, so it may be actually quicker and easier to deploy somebody into the UK on an intra-company transfer visa. And I will come on to processing times on visas shortly. It is a little bit more straightforward under the ICT routes, but unfortunately doesn't lead to settlement. So if you're looking at a long-term plan, skilled worker, if you're looking at a short-term temporary assignment, the intercompany transfer would be the one to go for. And then finally, the Home Office also recognised the Frontier Worker Scheme, which doesn't actually fall within our UK immigration rules. It's an EU-wide directive, but we are party to that. It applies to EU, EEA and Swiss citizens. How the Frontier Worker Visa works is that it's for cross-border commuters, so those who live outside of the UK but need to come to the UK to conduct business and to do work from time to time. Okay, so they're primarily based outside the UK but want to come and work. The work itself must be genuine and effective. What that means is that it needs to be more than a simple business meeting or attendance at a conference or to have come here for an interview. It does need to be more substantial than that. The individual must have been active in the UK before the 1st of January. Now, what we've seen is that a lot of individuals were coming to the UK to work pre-COVID. weren't able to come to the UK last year, that's probably okay, as long as they would be able to demonstrate that they had been in the UK previously working in that sort of cross-border pattern. Then they should still be eligible for a frontier worker visa. They do need to apply before the deadline, which is the 30th of June. That's important. Do bear in mind these dates, because once the deadline's gone, it's gone. They won't reinstate this scheme. And the visa is valid for 5 years. It doesn't lead to settlement, permanent residency, but it can be renewed. Okay. The reason this might be attractive is because it's free to apply for, whereas the skilled worker and the ICT are quite expensive. I'll touch on costs as we go through, but the frontier worker is certainly something you might want to think about if you have employees who are doing that cross-border commuting, working, whether it's project-based, whether it's, you know, working from time to time in the UK. All right, so just some things to bear in mind. I'm now going to just go through the UK sponsor licensing requirements. I've looked at the visas available, but I should now sort of point out how a company can actually sponsor somebody. So in order for any organisation in the UK to employ a foreign worker, it's a prerequisite that they apply for a sponsor licence. So a sponsor licence is issued by the government, it's issued by our UK Home Office, and it's a licence that the company itself hold. Okay, the licence is valid for 4 years, and during the lifetime of the licence, you can essentially hire as many foreign workers as you need to meet the requirements, your resourcing requirements within the UK. Okay, there may be a group of you on the call that don't have a sponsor license, and there may be a group of you who do. I'm just going to go through, firstly, those who may not hold a sponsor license and the things that you may need to think about in order to obtain one. So as I've mentioned, it is a prerequisite. You couldn't employ somebody under a skilled worker or an intra-company transfer visa without holding a license, although the same isn't true of a frontier worker. A frontier worker visa is actually applied for by the individual, so that you won't need a sponsor license to have frontier workers working for you, but you will for the other two. The sponsor license process requires you to gather quite a lot of company documentation, accounts, lease, tax documents, and so on and so forth. You also need to appoint key personnel who are UK based, typically permanently based in the UK. So do have a think about who may be the most suitable to undertake the role if you are interested in applying for a sponsor license. You can outsource some of the roles, but the one role that you can't outsource to a third party or delegate to a third party is the authorising officer. That needs to be a fairly senior individual who has responsibility for making decisions within the UK. So quite important to look at that. Also to understand your compliance obligations. It's not simply a case that you submit a set of documents to the Home Office, the licence gets approved, and then you can go ahead and get your visas. You do need to understand what your compliance obligations are, because the Home Office at some point will want to come and audit your organisation. And essentially what they're looking to assess is whether or not you can manage these compliance obligations, whether you have robust processes and policies in place. And this is really sort of designed to make sure that you don't employ people illegally, that you can track your migrant workers, and so on and so forth. So on to my next point, which is understand your compliance obligations and then build robust processes around those. Now, they're essentially HR type of processes. So things like record keeping, maintaining good documentation, good right to work checks, things of that nature. But it's certainly worth thinking about that if you're looking at a sponsor license. And if you did need advice, then Newland Chase can certainly help with explaining what your compliance obligations are. It's really important to note that. And then submit a perfect application. I know that may sound quite obvious, but you'd be surprised at how often the Home Office will reject an application. They're actually quite an unforgiving department. So, for example, if you were to put in a document which wasn't certified in the right fashion, or if you simply missed a document, the application can get rejected, probably likely to get rejected, which means you're back at square one and you have to go through the process again. And as I've mentioned at the end, it takes about 6 to 8 weeks. So you've effectively lost 6 to 8 weeks in the process. You're back at square one. And if you have somebody who you're looking to hire, it just means that it's delayed that process. All right, so that's some of the things you need to think about if you don't have a sponsor license. And what if you do have a sponsor license? So what we find is that those companies who have a sponsor license and use it regularly, sort of week in, week out, they're usually quite fine. They have good processes in place. But for those of you who may have a sponsor license, but frankly haven't needed to use it because you haven't hired from the EU, or it's just something that you haven't used very often, then I would suggest that you go through an exercise just to ensure that the license is fit for purpose. So what do I mean by that? Well, first of all, the key personnel. I've mentioned that key personnel need to be appointed in order to hold a license in the first place. They also need to remain in place. So, for example, if you had an authorising officer who's now left the organisation, the license would actually be non-compliant. So do make sure that the key personnel who are named on the license remain in place. That's really important. If you have lost any of the key personnel, then you really should reappoint those individuals very, very quickly. As I say, you can lose your license if you're found to be non-compliant. Also make sure that your overseas entities are linked to the license. Again, I've mentioned the intracompany transfer route. If you are looking to transfer individuals from any of your overseas entities into the UK, then those entities do need to be linked onto the license. Okay, so it's really important that you know what businesses are linked and what aren't. And likewise with your UK offices, if you have a number of branches or offices around the UK, you can't simply send your employees to work in those offices if they aren't linked to the license. So again, probably worth having a look at the license, understanding what you submitted when you applied, making sure that it's in good shape right now. Also making sure that you have sufficient, certificates of sponsorship. A certificate of sponsorship is essentially the work permit that you issue to all your foreign workers ahead of them making their visa application. If you're expecting, because of Brexit, there to be a spike in volumes because either you need to hire more people from outside the UK or you need to transfer people into the UK, make sure you have enough certificates. And also make sure that you have both the skilled worker and the intercompany transfer tiers on the license. We've seen a lot of companies recently, a lot of clients of ours who have either had one or the other and are now wanting to have the option of both, just to keep their options open in order to be able to hire permanent and short-term people into the UK. Again, if you haven't got it, it's a process that you need to go through before you can use those visa routes. And also keep an eye on the license renewal date. I mentioned at the start that it's valid for 4 years. You can renew it on a 4-yearly cycle, but do make sure that your license does get renewed if you want to continue to use it. We've had companies come to us quite recently who have wanted to use the license and have realised that the license has lapsed. If it lapses, you lose the license and you need to apply over again, which is kind of a wasted exercise. You have to pay the fees over again, and it's an unfortunate situation to find yourselves in. So do keep an eye on that. The Home Office usually remind you at 3 monthly and then 2 monthly and monthly intervals. Okay, and then finally, ensure the in-house teams are au fait with the new immigration rules. We've spoken to a lot of companies who actually don't think anything's changed at all. Recruitment teams, for example, recruitment departments. Even recently, Brexit has not been a secret, but even recently we've had recruiters come to us saying, well, we can just bring EU nationals like we always used to, right? To which the answer is no, as hopefully I've explained quite clearly. So again, global mobility teams, if they're not au fait with Brexit, the new immigration rules, then I think now is a good time to remind them that things have changed. I've mentioned the processing times. The Home Office is slow. They don't move very quickly on anything, to be honest with you, and can take up to 10 to 18 weeks to get some of these things processed. So if you do need to action any of the points I've mentioned, I would suggest you do it sooner rather than later, given that it takes so long to get things done at the Home Office. So just a parting message, don't get called on the back foot. So that's the employment routes in the UK, and hopefully that's quite clear what you need to do if you need to employ foreign workers now, including EU nationals. I'm just going to now go through business visitors, because likewise, Brexit has impacted the ease of which an individual can travel to the UK. I've mentioned there in my first point, the end of free movement represents a marked shift in working culture of European operations, and that's frankly true. Already we've established that you can't just move EU nationals into the UK to work, they now need work permits. But also with business travel, that's changed too, not quite as easy as it used to be. The first thing I want to mention is that EU nationals do not require a visa per se to travel to the UK. So like Americans, Australians, New Zealanders, they're not considered to be visa nationals, which means they can just come to the UK. But unlike in the past where they wouldn't be scrutinised, that's changed, okay? When I talk about scrutiny at the border, an immigration officer will go through a standard set of questions, which of course then raises certain risks, and I'll mention what that looks like shortly. But the sort of scrutiny that you're going to be looking at are things like, why is the person coming to the UK? How long are they staying? And what is their pattern going to look like? Will they continue to come to the UK and travel back and forth? And are they going to start to establish a pattern, which could raise some risks? Okay, so you need to be familiar with what a business visitor can and can't do. Okay, as I mentioned, greater scrutiny of intra-office business travel will be paramount. And I guess that will fall on either the travel teams or the global mobility teams. So what are the risks of sending somebody to the UK on a business visit if they're actually coming here and they want to work? Well, they can be refused entry, and we've already seen this. I had a client, a French lady, who came to the UK only a couple of weeks ago, needed a work permit, didn't have a work permit, and was refused. Okay, so it is happening. You do need to ensure that you're clear on why they're coming here. And if they need to work, then you need to get them a work permit. She didn't get into the UK. It can also have a direct impact on your sponsor status if you do hold a license. I've mentioned illegal employment. If somebody were to actually get in as a business visitor, but then was found to be working, then they would be in breach of their conditions, and that can attract a penalty of up to £20,000. And then there's obviously the reputational damage. You don't want to be caught with illegal workers working for you. There is a name and shame list that the Home Office publish, and it's just an unpleasant situation. Okay, so things to be thinking about. So of course, there are general principles of what a business visitor can do. So I've mentioned the time. So they can travel to the UK for a reasonable period of time. Unlike the EU, we don't have a strict limit on how long somebody can come to the UK. It's not sort of 90 days and 180 days. It's just a reasonable period. What do I mean by reasonable? Well, I would suggest that anything more than 30 days in a single trip would start to raise red flags. By its very nature, a business trip is short term. And I'll come on to the permissible activities, but the sort of things that somebody would be coming here on a business trip to do really shouldn't exceed 30 days. There's a list of permissible activities. I'll come to those in a second. Also think about travel and the frequency of travel. Is somebody coming here for a couple of weeks, leaving for say a week and then coming back again for a couple of weeks? If they are, and they continue that pattern, that's going to start to create issues at the border. Again, if they are doing that pattern, they may just need a work permit, or you may want to think about getting a work permit to mitigate the risk. Okay, they can of course keep in contact with their overseas employer whilst in the UK, receive reasonable travel and living expenses from sources in the UK, but they must not transfer their base of operation or their payroll to the UK. I often get asked the question, well, when they're in the UK, can they sort of check their emails from so they can keep in touch? And of course they can. That's no problem at all, checking emails, but they can't do substantive work in the UK. All right, so what can a business visitor do? Well, the obvious things are attending meetings, conferences, seminars, attending interviews. I think these are sort of fall within the obvious business visitor setting. They can give a series of talks, negotiate trade deals and contracts, attend trade fairs. In certain cases, carry out site visits and inspections. But if we're starting to get to meetings with clients, you need to be a little bit careful there. This is where it starts to get a little bit grey, if you like. Gather information for employment overseas. That can include discussions with clients or UK colleagues. But again, once we start to get into that type of activity, you do need to make sure that it's permissible. It can sometimes go beyond what's permissible. And again, a work permit would be required. And also briefings for UK customers. So I wouldn't say this is an exhaustive list, but some of these are quite obvious. and clear. Others, maybe they fall into a slightly grey area where you might need to discuss in a bit more detail the activity. I've also set out some of the intracorporate activities, so advising, consulting, troubleshooting, provided training, knowledge transfer, skills transfer. This is usually internally. If they're doing it to external stakeholders, clients, customers, it may not be permissible. Also provide internal, again, that word internal is important here, because often is the case that this can only be conducted internally, but give regulatory or financial audits. If you had somebody who was an auditor and they were doing it at a client, wouldn't be permissible under a business visit, so they would need to get a work permit to do that. And just again, reminder that the duration needs to be short. A month or more is going to start to attract suspicion. Mustn't be involved in directly working with or for clients. And should be based mainly at the UK company offices and not at client sites. There are some exceptions to that. Again, it's about that due diligence process, really understanding what they're coming here to do, and figuring out whether or not a work permit's required or not. And just some final points on business visitors, which they absolutely can't do. So they can't take employment in the UK. I hope that's, I've sort of set that out quite clearly now. Employment needs a work permit. Also, establish or run a business. Self-employment is prohibited. That just can't happen. Undertake a work placement or internship. Now, this is something we've been asked a lot recently. Again, under free movement, EU nationals would come to the UK. They'd spend 3 to 6 months doing a summer internship and go back home. A business visitor does not facilitate an internship or a work placement, okay? There are schemes in place to allow overseas nationals to come to the UK and undertake internships, just not under the business visitor rules. It doesn't fall under the skilled worker or intra-company transfer routes either. We have different schemes in place. So don't fall foul of assuming that you can continue because it's not, permanent employment. And also provide temporary cover or short-term cover again. If the cover is in an established role in the UK, even for a few weeks, then a work permit would be required. So again, you need to take that holistic view when you're assessing whether or not somebody can come here as a business visitor. The activities are one thing, but also the duration, okay? And we often get asked, well, they're going to be working, but they're only going to be doing it for 3 or 4 weeks. That's okay, right? No, that's not. A work permit would be required in that scenario. So again, just think about it from all the different angles. Can't sell goods directly to the public, can't provide services unless otherwise permitted, which I've already set out. And also to remember that the employment needs to remain outside the UK as well as the payments. Okay, so hopefully quite clear what can and can't be done, but if there are any questions, then do feel free to post those. So just a few practical tips for successful business travel. I know we're on the hook with time, so I'm going to speed up slightly. So passports. The UK only require the passport to be valid for the duration of the ongoing travel. So we don't expect it to be for 6 months like some of the EU countries do, just needs to be valid for the point of departure. You can continue to use your national ID cards, but only up until October of this year, unless you have status under the settlement scheme. Then I think it's going to be valid until 2025. But do think about, if you don't have a passport, if you've been travelling on an EU national ID card, then you might want to think about applying for the passport. We would highly recommend for your business travellers that you give that you provide them with a justification for travel letter, what we call a back pocket letter. As I've mentioned, the added scrutiny at the border will start to raise questions, and we find that it's just easier if you provided a letter. It just facilitates that ease of entry to the UK. What needs to go in the letter? Things like the nature of the activities, clearly setting out that they fall within the remit of the business rules and that it's not for work. You can state the duration of the travel, that it's a one-off, and that you're covering the expenses. Okay, so that's absolutely fine to include, but I would recommend you do that. I think it just avoids any uncomfortable conversations and set that clearly for the immigration officer. I've already mentioned that the financial means can cover the duration of stay. That's no problem at all, but a salary can't be received. And just the itinerary. I think it's quite helpful if they if they travel with evidence of their accommodation, so if they have a hotel booking, also the outbound travel, that evidence is the fact that they're going to be leaving within the time they've said. Okay, so just those are really just practical tips and just a few things in summary. So the impacts of Brexit, hopefully I've highlighted sufficiently that ease of travel is going to change and change quite significantly. Free movement, it was easy. You could hop on a plane or train or ferry and essentially be in the UK and start working. That's changed and that's no longer the case. Also the costs, I mentioned costs or I alluded to costs earlier. It's not inexpensive to sponsor somebody in the UK. To give you an example, a skilled worker visa for somebody for 5 years on the government fees alone can cost somewhere in the region of about £9,000. Okay, so it's expensive. Think about the timelines. When seconding somebody, it's going to be longer than it was in the past. That's just a fact. Visas take a while to apply for. This can have an impact on start dates in the hiring process. Added scrutiny around business travel, I've already mentioned. And also the mindset shift. Again, we've had conversations very recently where companies don't seem to think that anything's changed very much at all. And I'm hoping that I've highlighted the fact that it has, and it's changed quite drastically. So just to get, those who are involved in travel and global mobility and recruitment, just to ensure that they're au fait and familiar with what's happened. Things to consider, I've already mentioned the sponsor license process. Assess the need for a sponsor license if you don't have one, and if you do, then obviously make that make sure that it's fit for purpose. Also reevaluate your in-house resources and capacity. If you're expecting to use immigration visas more and more than you used to in the past, and just make sure you have teams in place to be able to deal with the spike in demand. And I've mentioned compliance. I won't labour the point, just to say how it is important and make sure you're familiar with your compliance obligations. And just finally, what to do now? Well, apply for a sponsor license if you don't have one already. If you want to continue to hire talent from outside the UK, the talent pool shrunk, and it's just the domestic labour market that you have access to now without needing to apply for a visa. Review the existing sponsor license for the reasons I've mentioned. Educate internal stakeholders. Who would they be? I would say typically global mobility, HR, travel and recruitment teams, but maybe even the wider business community. Maybe you have business managers who have been used to deploying, individuals onto projects, for example, and quite easily doing that, whether that's client projects or in-house. Maybe they need to know that things have changed quite drastically and that visas will need to be applied for. There's time and cost implications, as I've already mentioned. And just make sure that your processes, either develop your processes in anticipation of applying, or have a review of those processes to make sure that they are and continue to be fit for purpose. The busier you get, the more visas that you apply for, the more robust your processes need to be able to cope. And just a parting message, I suppose. Just remember that all work, no matter how short the proposed period, cannot be undertaken on a business visit. It does need a work permit, so do have a think through what that looks like. And again, Newland Chase manage the end-to-end process. We can help with compliance. We can help with applying for a sponsor license. So if you are in any doubt, if you would like some assistance, then do feel free to reach out. And I will pause and come up for air and hand you over to Joyce, who's going to finish off.
Thank you so much, Tony. Thank you for all the information given. We can imagine it's quite a lot, and there are quite a lot of gray areas as well. It's definitely not an easy matter, and it will change like the travel landscape to the UK or the other way around a lot. So what CIBT did, we were approached by a number of clients who had a lot of questions, and we worked together to create a post Brexit assessment tool that is live on all CIBT websites, whereby you can do very easily a kind of assessment, make sure that you select the right nationality. On the Belgian website, it is automatically in Belgium, but you can change it to any other one. Traveling to the UK, and then about 10 questions will be asked. if all these questions are asked and the system will assess that no visa is needed, you can still create a kind of comfort letter, as Tony said, a back pocket letter whereby the traveler can take it to the UK and present it when arriving. So at least the traveler feels a bit more safe to be like, okay, I did an assessment, and out of this assessment, I do not need a work permit. If we have doubts, so the assessment is saying, okay, we really need a bit more investigation, then there is a 15-minute free consultation by a Newland Chase colleague who will approach the traveler or the travel arranger directly to have a 15-minute phone conversation to really make sure that a visa is not needed, or in a case it is needed, we will make sure to tell you what type of visa it will be. And it's not necessary, but we are able to assist you as well from the Newland Chase side. So that's live on the CIBT Visas website. If you have any question, if you want to have a demo around that, please feel free to contact our office. We have 2 minutes left. There are some questions. Tony, can you see that these as well? These are quite linked to like the slides that
Sure.
Maybe we can take out a couple before.
Yeah, happy to. I think we've got a bit of time. Pascal, if you're happy for me to go through the questions.
Yes, absolutely. Go ahead.
Wonderful. Thank you. Great. So let's have a look. I'll take them from the top. So the first question is regarding the language skills and whether a proficiency test would be sufficient. And this would be for the skilled worker visa. So actually the Home Office publish a list of English language courses which qualify. They're called CELTs, which is Secure English Language Test. And you have to take one of those tests, okay? It also needs to be at the requisite level. There are essentially 3 levels for the test. There's A1, B1 and C1. And for the skilled worker, the requirement is to pass a B1 level. So it does need to be done by one of the Secure English Language Tests, which is permissible by the Home Office. Okay, if it doesn't meet that requirement, then it wouldn't meet the requirement of the skilled worker visa. And they publish the list quite helpfully, so you can go online and find the list and find out which test centres are, where they're based, and so on and so forth. And the next question is regarding frontier worker visas. So frontier workers visa, how to prove, for example, which documents or other evidence that the individual was active in the UK? That's a really good question. The scheme, we've only started using it for a few months, but we have processed actually quite a lot of applications now. And we're starting to see that the Home Office are being actually relatively pragmatic in their acceptance of documents. The sorts of things that we would expect to see would be letters of employment, pay slips, invoices if you're self-employed or if you're running your own business, letters of engagement, statements of work, things of that nature, even bank statements, deposits made to bank statements. Those sorts of documents would be good evidence that the individual has worked or undertaken a form of economic activity in the UK. I should have pointed out, if it wasn't clear, that a frontier worker can be both employed and self-employed. They can do contract work. The point of the frontier worker visa is that they've done some economic activity in the UK, but done it as a cross-border commuter. So the type of employment that they've been in isn't necessarily that relevant. It's about proving that. So again, you know, those documents I think would quite nicely establish that somebody has been in that economic activity. You've mentioned 5 years, but actually what the rules say is that they should have been able to demonstrate they've worked in the past 12 months rather than the past 5 years. What we've seen is that because of COVID, the Home Office have exercised a little bit of discretion in going back further than 12 months. But I don't think if somebody had worked here 5 years ago, they'd actually qualify. So it needs to be a little more recent than that. Okay. And then there's a question, as a UK national resident in Europe, can I run a business in the UK? Yeah, that's absolutely fine. There may be tax and social security implications, but from an immigration perspective, that's no problem at all. well, certainly from a UK immigration perspective, there may be a question mark around what the immigration rules look like for you in the country that you're currently residing in. I'm not an expert on EU immigration. We do have an advisory team who would be able to help with that question. So if you wanted to contact us at the inquiries email, which is on that slide there, then we could certainly help in answering that question for you. And just the final one about the justification letter. The question is, does this have to be on a letter on paper, or is an email acceptable? Certainly on letterhead, company letterhead would be far more preferable than an email. And I would highly recommend that if you can get the back pocket letter or the invite letter on letterhead, then that's the way to go. I wouldn't recommend using an email. You may be okay with an email, but we always recommend that it goes onto the company letterhead, whether that's the host in the UK or the company who are sending you, it should go on their letterhead. So that's the way I would go with that. And I think that wraps up the questions, Pascal. So I will hand back over to you.
Thank you very much, Tony. So we're running only 3 minutes over, so that's great. I want to take this opportunity to thank CIBT, Joyce and Tony for the partnership this morning. I think it was a very insightful and very interesting webinar, which gives a lot of information that is very useful to our members. So thank you very much for that. And the only other message that is left for me this morning is to thank everybody for joining. Stay healthy, and we are looking forward to welcoming you at one of our future events. Stay tuned. There's a lot more to come during 2021. Thank you. Have a great day and talk to you soon. Bye-bye.
Thank you, everyone. Bye-bye.